Good afternoon, everyone. Welcome to our Q&A Business Forum. My name is Wes O'Donnell. I'm the National Workplace Relations Manager with HR Assured. For our clients that have joined us in these sessions previously, welcome. Thank you for joining us again. Be better to join you under more pleasant circumstances, but as you're aware, in 2020, we undertook a Q&A business forum approach to the pandemic, given the very dynamic nature of the pandemic and the evolving nature of rules, etc., and various government regulations. It's probably fair to say that there's been a bit of confusion in the New South Wales experience, at least, concerning the nature and effect of various restrictions and government assistance available. And broadly speaking, in a general statement, that confusion has arisen given the evolving nature of the current pandemic, but also the changing rules almost on a daily basis. So for those that haven't joined us previously, welcome. What this forum will be is not a lecture style, but rather we aim to provide you with the most up-to-date, relevant information to assist you in making informed business decisions in your company. We will, of course, provide a lot of opportunity at the end to address particular questions that you may have, and the opportunity that is provided for you to effectively tap into me and some of my other colleagues throughout these forums, which will be conducted on a regular basis. Please feel free to ask any questions throughout the course of the session. Where I can, I'll try to address those questions through the session, or alternatively, we will try to leave approximately 20 minutes to half an hour at the end to address questions. And we think that's a really effective approach, given that the questions that you generally have will be shared by others, no doubt, in this session, okay? So the main focus of today is to address, obviously, the Greater Sydney lockdown and its implications upon business. For those that don't know me, my name is Wes O'Donnell. I'm the National Workplace Relations Manager with HR Assured, and effectively manage the service delivery side of our business, which includes the telephone advisory service, where we support our clients and members of various associations with around 50,000 calls throughout the course of the year. And we are seeing an increase in calls in the current state of play in New South Wales. So the purpose of today's session is to really address a couple of things. Firstly, what is the current state of the lockdown in New South Wales, and what does it mean for you operating a business? Yeah. Things have moved rapidly in New South Wales, and announcements have been made as recently as Saturday and then reverted on Sunday. So there is some confusion. We are seeing as well that various government assistance packages have also been announced, and various qualification criteria has been revised, updated, or clarified over the past 10 days, again, which is causing some level of confusion with clients. So we're trying to cut through that level of confusion and trying to provide an overview of what the most relevant and accurate information is at this point in time. Yeah. We'll also provide a brief overview around overarching WHS implications that need to be considered throughout the pandemic. Of course, our primary obligation as an employer is to protect the welfare and well-being of our employees where we can, to the extent that is reasonably practicable. So we'll go through some of those, because obviously employees are concerned or have their own concerns around the current state of the pandemic, particularly from those within particular government areas. We'll, of course, outline how to manage the various restrictions, how to enact a stand down, and various government support packages which are available. So in terms of the current pandemic, this presentation is obviously limited to the New South Wales experience. Moving forward, it is likely that the regular catch-ups will be extended to incorporate other states, given lockdowns which have recently been announced in Victoria and South Australia. But it's fair to say that the experience in New South Wales has been dramatic. Since the current outbreak has been announced, over 1,200 cases today have been announced. Yeah, that includes today's figures. So as at the 18th of July, we're at 1,171. Compare that against the total cases since the pandemic commenced in January 2020 of only 2,736. It goes to show the extent and gravity of the current outbreak which we're currently living in. And I think that when we look at those figures, starts to suggest that the lockdown or current restrictions in some form, in my personal view, won't necessarily be short-lived. And I think that there needs to be a deeper appreciation of that so that we can have a more informed discussion around ways in which businesses will respond, plan, and support their people through this process. I'm sure all of you have watched or heard of the recent announcement at 11 a.m., but 78 local cases were reported in the last 24 hours. Approximately 27, I could be corrected, 27 of those were known to be infectious in the community at some stage through that period. So the current state of restrictions in New South Wales are in effect relating to the movement of people, as we would expect. There has been a stay-at-home order in place for some period of time. That stay-at-home order effectively limits the ability of an individual within Greater Sydney to leave their home unless there is for a reasonable excuse, which we'll go through. Further restrictions have been recently applied to residents of Fairfield, Liverpool, Canterbury, Bankstown local government areas. And more recently, there has been an introduction of a definition of critical retail, meaning that retail businesses other than those defined as critical are prevented from trading. And somewhat controversially, on Monday, all repairs, maintenance, cleaning, and civil and domestic construction have been suspended for at least a 2-week period. We'll go through each of those in turn, but we'll just go through a few things arising from that. So naturally, as we look to plan, and we will go through each of those in detail, a couple of tips that I can provide. Consider what the operations effectively mean for you. Yeah? What can you and your business do as a result of these restrictions? I fully appreciate that there are many businesses, many of which have joined us today, including dentistry, which haven't necessarily been directly referred to within the public health orders as either a permitted or excluded operation. So in many senses, there is a requirement for businesses to undertake an assessment of what they can do, firstly, lawfully within the meaning of the public health orders, but then secondly, take a further deeper level of analysis around what they can safely do in the context of their operations, which preserves the safety and well-being of both their employees, customers, members of the public, etc. So there seems to be a two-tiered approach, both in relation to legislation, second in relation to risk and health and safety. Consider whether it's reasonably practicable for employees to work from home. We appreciate that many can. However, many businesses cannot have employees work from home given the nature of the duties they perform in the workplace. Where that is the case, consider whether employees can be directed to undertake training or some form of development process, at least for a period of time. We should be undertaking a risk-based assessment, which is a requirement through WHS legislation to ensure that our people are working from the workplace in a safe manner and in a COVID safe way, or alternatively, where employees are working from home, we've undertaken an assessment of that working from home environment so that effectively we are ensuring that they are safe at home, that there is an appropriate setup which is consistent with your health and safety obligations. Where necessary, we can consider temporary redeployment to other work locations, and this is particularly the case given the differing approach with various LGAs, which we'll go through, and consider what impact the current restrictions are having on your business from the perspective of clients, suppliers, contractors, etc. So whilst you may be able to continue trading and operating, are you effectively prevented from doing so through agents, contractors, suppliers not being able to engage with your business as normal? Where an assessment has been undertaken and you have determined that you are unable to trade due to public health orders, you can implement a stand down, which is what's called a Section 524 stand down, which effectively means that employees will be stood down without pay for the duration of the stoppage of work. There's a number of essential criteria which must be first met in order for a business to effectively stand people down. The first is that there must be a stoppage of work due to and then secondly, that the circumstances must be beyond the control of the employer. So firstly, must be a stoppage of work, not a reduction in trade, given the overall state of the pandemic. So a reduction in operating hours of itself is not a stoppage and would not enable you to implement a stand down. There needs to be a stoppage of work of the entire business or a particular identified division of it due to circumstances beyond your control. Now, as I've mentioned, in the event that your business is prevented from trading due to the nature of the public health orders, that's a very clear example of where you're prevented from trading due to circumstances beyond your control, and we would suggest that the ability to implement a stand down would not be challenged. Where a business is making an informed risk decision to close or cease operating, given the broader state of the pandemic, that's somewhat a little bit different, given that it's an elected decision of the employer. And we appreciate that there are very significant and overarching public health concerns which may justify that decision. But that's a decision which I think really should be conducted in consultation with an advisor and us as HR Assured, so we can step you through that to make sure that you've considered all of the options and that effectively the stand down wouldn't be subject to challenge, or if it is, that you're maximising your prospect of success. If you as a company are wanting to undertake or implement a stand down, it's not required. However, we would strongly recommend that employers grant employees the option to take paid leave during this period of time, so as to avoid any unnecessary financial burden upon them. As I've said, it's not a requirement. An employer can impose a stand down, and during the period of stand down, employees aren't able to utilize paid annual leave without your express prior consent. But it's a great option to implement to avoid any unnecessary financial burden upon your employees, to minimize the impact of the stand down, and to also maintain deep engagement with your employees during this period of time. Of course, as always, in the event that employers are wanting to implement a stand down, I think that we should always be consulting with our employees in advance. And yes, there is a need to confirm the nature and effect of the stand down or the decision to take leave in writing, so as that is not necessarily confused or disputed in future. So we're more than happy to provide further support around the nature of stand downs and how to effectively implement it, but it's one option available to businesses. We found as a general experience that upon the commencement of the lockdown in New South Wales, many businesses were continuing to trade, thinking that the lockdown may be for a defined or limited period. Businesses were also electing to continue payment to employees so as to reduce any financial burden. We are seeing, however, that employers are changing their views in that regard, generally speaking, arising from the suspected duration of the lockdown. Many in the community are thinking that the lockdown will be of a much greater duration than what was initially anticipated. But secondly, the introduction of government support initiatives has created a safety net for employees, for want of a better description, and many employers are therefore reconsidering their position around stand down and options provided to employees. And of course, if you'd like to talk through any of those particular options, we're more than happy to have that discussion on a direct basis with you to help step through those options. So we're going to spend a little bit of time now going through each of the respective restrictions and also the details of the current support packages which are available. The current state of the stay-at-home orders are that any resident of Greater Sydney, which includes Blue Mountains, Central Coast, Wollongong and Shell Harbour, must stay at home unless for a reasonable excuse. Now, the public health orders have Schedule 1, which outlines the reasonable excuses, which we'll go through in a moment, which enable a person to leave home. That has been updated relatively frequently upon the start of the lockdown. However, hasn't been updated for a while. So I'd suggest that that definition of reasonable excuse is rather well established. Okay? Over the course of the weekend on Saturday, the government announced a further restriction such that residents who specifically reside in the Fairfield, Liverpool or Canterbury Bankstown local government areas are unable to leave that local government area unless they're an authorised worker. The announcement on Saturday limited the definition of authorised worker to emergency service personnel or healthcare workers. However, substantial variations to that list of authorised workers were made on Sunday and further again on Monday, and we'll go through that current list. There's also a restriction on residents of Greater Sydney who travel outside of that area within a 50-kilometre radius for the purposes of work. So any resident of Greater Sydney who works outside of the Greater Sydney area within a 50-kilometre area must be tested every 7 days when they continue to work outside of the Greater Sydney. A further restriction is placed upon an occupier of a workplace where they must not allow any person or worker to attend upon a workplace unless they can show a negative test result every 7 days. So it's very interesting that this particular restriction places both a direct onus on employees who travel outside of Greater Sydney for the purposes of work, but also upon employers to check that each employee in that cohort has received a negative test every 7 days and records a copy of that. So obviously those businesses within that particular area just outside of Greater Sydney would have an obligation to put appropriate systems in place to identify employees which live in the Greater Sydney area and then put further systems in place to ensure that they are frequently checking that negative tests have been received and recording a copy of that. As mentioned, people must stay at home unless for a reasonable excuse. Now, there's been a great deal of commentary in the media around the level of confusion arising from the public health orders, and I must say that I agree that there's been a level of ambiguity and confusion given the state, particularly the ability for businesses to trade which were not specifically prohibited. But generally speaking, the reasonable excuses include, but aren't limited to, obtaining food, goods or services for personal consumption or on behalf of vulnerable persons, attending work if the person cannot reasonably work from home. And there's been an update yesterday, which came into effect yesterday, to that particular requirement, such that an employer cannot unreasonably refuse, which has always been the case, an employee's request to work from home, where an employee cannot reasonably work from the workplace. But the most recent update to the public health orders has increased the penalties quite substantially, which can be imposed against an employer who directs an employee to work from the office or refuses their request to work from home where it would be reasonable to work from home. A further definition has been included stating that an authorised worker is those that live in the Fairfield, Liverpool or Canterbury, Bankstown LGAs. They're also authorised to leave. Another reasonable excuse is participating in education if it's not possible to do so from home. However, most educational facilities have ceased or prevented providing face-to-face facilities. Exercise or outdoor recreation, conditional upon you not leaving a 10-kilometre radius from your house or leaving your local government area if you live in Fairfield, Liverpool, Canterbury, Bankstown, and a condition that no more than one additional person from another household joins you. Or, of course, attending medical appointments, including being tested for COVID or receiving a COVID vaccination. As of Monday, as I mentioned, the list of authorised workers which are permitted to leave the Fairfield, Canterbury, Bankstown local government areas has been broadened quite substantially, actually. So persons generally cannot leave a local government area unless they're an authorised worker. Authorised workers initially, as I mentioned, were confined to emergency service personnel or healthcare workers. Now that's been extended to supermarket workers, including bottle shops and alcohol retailers, neighbourhood shops. A little bit confusing there in the sense of neighbourhood shops, whether that is limited to groceries, food, etc. A neighbourhood shop, technically could be a clothing retailer, but I suspect, given that it's lumped together with supermarkets, it's a corner store or some other business selling, consumables. Shops that predominantly sell food or drink, employees engaged in or employed by chemists, pharmacies, employees working in businesses predominantly involving the sale of office equipment, pet goods, baby goods, medical, pharmaceuticals, supplies, etc. Employees engaged in hardware and building supply stores, landscaping material and garden centres, fuel retailing, etc. So we can see that the list is quite extensive and does enable quite a significant number of persons from those impacted LGAs leaving in the event that they're employed in these particular industries. If you are operating a business in one of these listed industries, I would be suggesting that you have a broad understanding of any of your employees that are residing in those local government areas. And of course, there is additional requirements, particularly with regards to the need to be tested, which would apply to those individuals. And again, broad systems would have to be put in place to ensure that where an employee resides in one of those impacted LGAs, yet works in your premises outside, that appropriate control measures are put in place to ensure testing and to minimise cross-exposure. So in effect, we've also talked about other businesses such as click and collect services, public administration and safety, healthcare, etc. But there is a broad list. I've tried to summarise them as best as I can. However, if you've got any questions around where your particular business fits in with it in that list, by all means, please reach out and we can go through that more specifically concerning your business operations. That being said, I'd like to spend a little bit of time before we throw it open to question and answers to discuss the financial support which is available to workers. I think this is a really important thing to spend some time on because, as I mentioned, the current available financial support, which is directed to employees, is a really important factor that many employers are now taking into consideration when deciding whether to impose an unpaid stand down or other forms of assistance and support available. And broadly speaking, there's two support packages which are available, one operated by the New South Wales government and the other the federal. The New South Wales government initiative is referred to as Pandemic Leave Disaster Payment, whereas the scheme operated by the federal government is called the COVID-19 Disaster Payment, and we'll go through both in detail. The Pandemic Leave Disaster Payment, as I mentioned, is a scheme operated by the New South Wales government, and it's designed to provide a level of remuneration or value to employees that have been directed by New South Wales Health to self-isolate or quarantine after the 17th of September 2020. So this is a scheme which has been in place for some time. And it was put in place last year as a result of feedback that the New South Wales government received that employees, or persons rather generally, were somewhat disincentivized to comply with quarantine or self-isolation directions, given the financial burden that they would experience. So this pandemic leave disaster payment was put in place to create a payment to employees to encourage compliance. And effectively, there's a couple of eligibility criteria. First, that a person has COVID-19 or has been a close contact of someone with COVID-19, or cares for a child under the age of 16 with COVID or has been designated as a close contact. The person must be at least 17 years of age, must be an Australian resident or visa holder, and note that visa holder criteria, which is different to the JobKeeper scheme, which controversially prevented many visa holders from receiving JobKeeper. This scheme is different. It's open to Australian residents or visa holders who are unable to work as a result of the direction from New South Wales Health and has no appropriate leave entitlements, including pandemic sick leave or personal carers leave. Now, I'll just emphasize that word appropriate leave entitlements because that word, or those words rather, that phrase is used both in the New South Wales scheme as well as the federal scheme and has been causing some degree of confusion. But in the New South Wales context, no appropriate leave refers to pandemic sick leave. There are various industries, aged care as an example, where paid sick leave is provided in the event that someone has COVID or directed to isolate as a result of COVID, and that's a payment facilitated by the employer. Or alternatively, an employee is taking personal carers leave because they are unfit for work due to being diagnosed with COVID or having the care responsibilities of someone with COVID. However, if someone does not have access to paid pandemic sick leave or personal carers leave because they are otherwise fit for work, then effectively they would be eligible for the disaster relief payment, pandemic leave disaster payment, which is $1,500 for each 14-day period of self-isolation or quarantine. The other scheme, which has been recently introduced, is a scheme which is managed by the federal government, which is called the COVID-19 Disaster Payment. Um, this was introduced recently and relates to eligible persons who live in, work in, or have visited a Commonwealth declared hotspot who can't work and who are unable to work after the 8th day of the lockdown. So there's a general qualification period first, but once qualification has been satisfied, so that's they continue to be locked down and unable to work for at least 8 days, it will be backdated to the original. Employees who are eligible must have lost income and continue to have lost income on or after the 8th day. And to be eligible for support in the initial 2-week period, there's a liquid assets test, meaning that they must have less than $10,000 in liquid assets to support themselves. Eligible persons must again be at least 17 years of age, Australian resident or a visa holder, be unable to work, and not receiving broader payment supplements or such as ab-study, income support, dad and partner pay, paid parental leave, or any other form of state-based disaster payment. It should be noted that in this context, there is also a qualification stating that no other appropriate leave entitlements are being paid. However, that does not include annual leave, personal carers leave, long service leave, etc. So again, the only inclusion within that appropriate leave entitlement as an exclusion is pandemic sick leave, which is operating under a particular modern award, or personal carers leave, where an employee is otherwise unfit for work. Other than that, if an employee has accumulated annual leave, personal carers leave, long service leave, etc., that does not exclude them from receiving benefits under the scheme. I don't think that particular element was communicated well in the initial stage of the disaster payment when it was rolled out, which resulted in many employees believing that they had to exhaust their paid annual leave or long service leave entitlements first before they were eligible for this payment. However, that's been confirmed not to be the case. Appropriate leave entitlements is generally limited to pandemic sick leave and personal carers leave, and an employee is not required to exhaust their accumulated annual leave, personal carers leave where they're not sick, or long service leave before they're eligible for the disaster payment. Lastly, the disaster payments offer some level of support which differs depending upon whether it's the first and second period or third and beyond, and the number of hours which have been lost. A little bit confusing, so I've tried to set it out within the table outlined on your screen now. As we've mentioned, it's an eligibility requirement that an employee has lost work and income after the 8th day and beyond. So generally speaking, that implies that an employee can't claim, in effect, for disaster relief payments until they've been out of work and lost income for at least 2 weeks, roughly speaking. However, if they qualify, the government will backdate the support to the first day of absence. So they will backdate it, subject to an employee not having 10,000 or more in liquid assets, which we discussed previously. So where an employee meets those eligibility requirements, continues to be out of work, has lost work and income as a result of the lockdown, and has less than $10,000 in liquid assets, the government will pay $325 per period, which is per week, where an employee has lost less than 20 hours per week, or will pay $500 per week where the employee has lost 20 hours or more per week. As mentioned, that's backdated to the first date of the absence. The disaster relief payment is facilitated by the federal government, as I mentioned. There is a very simple process to apply for this leave. It's managed through the MyGov app. It's really simple to do. Employees just simply need to answer a few questions. My understanding is there is no supporting evidence or material that needs to be uploaded. There's a declaration, and then payments will be facilitated each week into a nominated bank account. Where the period of lockdown continues, then an employee will receive $375 where they've lost less than 20 hours per week. And there's a few changes there I'll go through in a moment, or $600 per week where they've lost 20 hours or more. The interesting thing to note with the third period and beyond is that there's no liquid asset test. So if an individual has any liquid assets, regardless of its size, they are eligible for relief and payments from the third period and beyond, but may be excluded from payments in the first and second period if they have liquid assets exceeding $10,000. Just that first category of less than 20 hours, the eligibility rules differ slightly in the third and subsequent periods in that an employee must have lost between 8 hours and 20 rather than less than 20, so it's between 8 and 20, or a full day of work, which is defined as a full rostered shift which otherwise would be normally worked by a full-time, part-time or casual employee of 8 hours or less. So a slight variation to the definition there, which generally means an employee needs to have lost a full day or between 8 and 20 hours per week. So in that sense, I just wanted to go through those two payments. Again, I know it doesn't directly relate to any of us on the call. However, I think it is a relevant consideration given that the availability of some form of disaster relief payment to employees, in my experience, is feeding into an employer's consideration around what steps, if any, they take in this particular stage of the pandemic, whether they implement a stand down and whether they enable an employee to utilize annual leave, etc. So that being said, I did want to leave enough time to address any particular questions. We have a few coming through. Please ask as many questions as you need. Of course, you're always able to contact us directly after today's session if there's anything which we don't have time to get to. And I'm sorry, this is the first session, so we have talked a little bit more and we've only got 5 minutes to address questions. But of course, in subsequent sessions, we'll allow a lot more periods of time to address your questions, given that we'll just be giving updates and then general question and answer time thereafter. So the first question is there any further definition around you cannot reasonably work from home? We have some staff who claim their home situation is untenable to work due to other people, distractions, etc. Yeah, really good question. I say this as I'm working from my office today. It all depends and varies. And of course, we need to consider it on a reasonable basis. Distractions in and of itself, I think, would not necessarily be a sufficient explanation to avoid the requirement. It may be a reasonable excuse whether there is a systems requirement which isn't available to employees working from home. Whether there are personal circumstances such as domestic violence or other safety concerns which prevent an employee working from home, or whether it would significantly impact upon the organisation and the output in the event that they are required to work from home. So that assessment needs to be done on a case-by-case basis. Simply having children homeschooled or particular distractions in the home environment is of itself not necessarily sufficient. But of course, continue to engage directly with those employees. Next question is, can we please clarify what the third period is? Yes, good question. I didn't raise it because it is a little bit confusing. However, the government has identified the periods which relate to each particular state and the local government areas, because the declaration of a hotspot varies. So what we talk about is, and you'll see in the slide, that to receive government payments, an eligible person needs to live in, work in, or visited a Commonwealth declared hotspot. So the first, second, and third period relates to the first week after a particular area has been declared a Commonwealth hotspot, and equally, second and third period relates to the second and third period after an area has been declared a hotspot. I don't like generally referring people to government websites, but the Federal Government Service website does have a table of local government areas and when they've been declared a hotspot by the Commonwealth, and that will then broadly relate to what the first period or week is, second, third, etc. The next question is, can an employer ask the employee to use annual leave during the lockdown? Yes, you can. Really good question. You can request, or suggest rather, that an employee take annual leave during the period. You can't force it. There are certain circumstances that you can force an employee to take annual leave. I don't want to go through it here because the rules differ depending upon whether the employee is covered by a modern award or award free. But the circumstances in which you can direct an employee to take annual leave is generally pretty limited. What we would suggest that you do is, in the event that the business implements a period of unpaid stand down, we have a discussion with an employee around how that impacts upon them personally. That is, stand down will continue indefinitely for the duration of the lockdown, or whilst ever we continue to cease trading as a result. You will be unpaid. You are eligible to apply for federal government or New South Wales relief if you see fit. However, as an alternative, if you would like to access your paid leave entitlements, which is annual leave, long service leave, we can look to facilitate that. Now, the reason why I say it's an optional, and we saw this a lot in 2020, is some businesses, unfortunately, in 2020, needed to really restrict the number of businesses that can apply. Yeah. So what that means is, and sorry, go back a step. Number of employees, businesses had to restrict the number of employees which could access annual leave from a pure cash flow perspective. So if you're imposing a stand down, it's considered best practice to allow employees to utilise their paid leave entitlements if you can do so. But if it presents a significant cash flow issue where you can't continue to pay employees without receiving revenue, then technically there's no obligation upon you to do that. Okay. Next question is, I'm a dentist. What if there is a drop in business, so less hours are open for the business? Can we stand down a casual staff member? Really good question. Apologise if I wasn't clear. Casual staff members don't receive payment unless they are working. So in effect, you don't need to stand down a casual employee, but there's no obligation to provide a casual employee with shifts. Yeah. So it is common within a period of downturn that a business will look at options to minimise their labour cost base, and that might be restricting or reducing hours performed by an independent contractor. Might also be reduction or removal of work performed by casual employees, etc. But casual employees wouldn't necessarily be stood down, but rather we just wouldn't be offering work during that period of time. Question is, can you please confirm if directors can apply for COVID-19 disaster payment? The disaster payment is available to any employee, as I understand it, who has been unable to receive work and has lost income. So where you are a director and an employee, so an executive director, then you can apply. Where you are a non-exec director and simply act as a director and receive director remuneration, my understanding is that you are excluded from the scheme. Sorry, lots of questions coming in. We know we're a little bit over time. So I'll just pick a couple out if I could. And then in the event that there is anyone else that would like to raise any questions, we're happy to address that individually. So a question is, I have a full-time employee who has chosen no paid leave during the current pandemic, but she still has some annual leave balance. Given that she chose to take unpaid leave during this period, will she be eligible for applying for the disaster relief payment? Yes, she would. Where an employee has been stood down or is taking a period of unpaid leave during the pandemic, again, they are not prevented from taking a period of disaster or seeking disaster payment where they've lost income as a result. And it doesn't affect their eligibility if they have accumulated annual leave payments. The only exception, and this might be the case in your example, is if an employee is already on a period of extended unpaid leave. They might be on an extended holiday, they might be studying as an example, etc. Then they can't retrospectively apply for disaster release payments because they haven't lost work or income as a result of the lockdown or been declared a hotspot. So just probably pick one last one if I could. A question here is, can we make staff redundant during this time? I'm very sorry to hear that the impact upon your business is so significant, firstly, but yes, you can. It's always an option available to you to make redundancies at this point in time. I would welcome a deeper conversation with you around how you can structure and plan that, because there's a couple of options available to you. One, many businesses we saw in 2020 decided to defer formal redundancies so that they would have employees who were able to assist them in the upturn once restrictions were lifted. Appreciate 2020 was different because of the JobKeeper scheme, but many businesses elected to effectively do that. And what they decided to do was to implement an unpaid stand down, which meant that they didn't have the labour cost during that period and could then effectively defer the decision for redundancy in future. Having said that, if you know that difficult decisions need to be taken, there is most certainly the possibility to undertake a restructure and redundancies now. Yeah. Couple of tips with that, and I'd certainly recommend that we assist any business that are wanting to undertake a redundancy process on a more comprehensive basis. But a couple of things we would look at is, are there contractors or casuals that can be potentially removed at first instance? Are there individuals that have less than 6 months or 1 year service, depending on whether you're a small or large business, which means that they don't have access to unfair dismissal, which means that they may be potentially selected for redundancy at first instance. Other than that, you will have to undertake a formal redundancy process and consult and require in accordance with the enterprise agreement or modern award. It should be noted that any employee who is made redundant and their employment ceases as a result of the redundancy and has less than 1 year of service has no entitlement to redundancy pay. So that's an important consideration from a cost perspective. Any employee with at least 1 year of service will receive redundancy pay between 4 weeks up to a maximum of 16 weeks, depending upon their length of service. An employee will also be entitled to notice, and that ranges from 1 to 5 weeks depending upon age and length of service. But it is open to you to provide notice during a period of stand down, which means that that period of notice will be unpaid. Whereas if you pay in lieu of notice, there is typically a requirement to pay what otherwise would have been payable during the notice period had it been worked. So there certainly is an option for you to undertake redundancies. There is certainly the ability to streamline that process to minimize cost during this particular period of lockdown. And if circumstances are so significant, there is also the option to make an application to the Fair Work Commission to reduce the redundancy pay down to zero. If it would be, otherwise there would be significant financial impact upon the business as a result of having to pay redundancy pay. So, long way of answering a simple question, but yes, you can undertake redundancies, and I'd invite you to have a deeper conversation with either me or one of my consultants to help you plan through that process if needed. I'm sorry I've gone over time firstly, but secondly, sorry that I haven't been able to address everyone's questions today. I appreciate that this is a dynamic period in New South Wales and Greater Sydney at least. We will be holding these sessions on a regular basis to provide updates to our valued clients and contacts around information that I think needs to be known or where there's a level of confusion. And in subsequent sessions, there'll be a greater period of time in which we can answer your questions. For those of you who aren't a HR Assured client, we would certainly still invite you to contact us if you would like any form of complimentary consultation or support. And the telephone number is down on the bottom of the screen for those who aren't clients. For those who are a HR Assured client, I would invite you to call our telephone advisory service, which is available on a 24/7 basis to support you through this particular time and these difficult circumstances we find ourselves in. Or for those of you who are a member of one of the associations we support, please feel free to contact the telephone advisory structure through that particular association. So thank you very much for joining us. For members of HR Assured and clients, valued clients, please don't hesitate to reach out if we can support you and your business through this difficult time. We'd love to support you in any way we can. And for those of you that aren't clients but would still nonetheless require some help, please don't hesitate reaching out. We know it's a very difficult and confusing period of time to operate a business, and we're certainly happy to offer our support wherever we can. So thank you very much, and please look out for our future invitations around future sessions. We'd love for you to join us, and if we can be of any support, please don't hesitate to reach out. Thank you.